Students in Delhi and Uttar Pradesh mostly have been protesting the new anti-discrimination rules brought about by the University Grants Commission, the regulator for colleges in our country. They've been saying that these new anti-discrimination rules that are meant to protect students from the SC, ST, OBC communities are actually not good. Now, there were street protests, there were political resignations, there were people who said that they will no longer support the BJP as a party, and then there was a legal challenge that went to the Supreme Court. The matter escalated quite rapidly, but now there is a major update. The Supreme Court today has ruled that these guidelines will now be kept on hold, calling them vague and saying that they could have sweeping, dangerous consequences and could even divide society. In this video, we're going to talk about what exactly happened in court, why the Supreme Court intervened, and what happens to the rules now. But we'll also discuss the history of these rules, why they were brought in place, and what the problem or the conflict area actually was. So remember to like, share and subscribe. I want to give you some background. So I actually worked out an entire explainer yesterday, which we recorded and we had ready for today. But now we had an update from the Supreme Court. So we've had to junk that and come up with an updated version. So we have a lot of history and a lot of information for you in this. But before I get to it, a quick reminder to sign up for our membership. It will really help us if you do. You can find it on the homepage of this YouTube channel. And leave me a comment, because I really want to know what you think about this subject, the subject of caste rights, especially in universities and institutions, I think is really important, and it's something that we should each individually think about and form opinions about. So do your own research, and after you watch this video as well, leave me a comment and let me know what you think, because I'm genuinely interested in what each of you have to say. All right, let's get to it. Now, over the last few days, students from colleges in Delhi and Uttar Pradesh have been staging protests against the UGC's notified guidelines. Remember, the University Grants Commission is the regulator of higher education in India. On Tuesday, students protested outside the UGC headquarters in Delhi, calling for a rollback, and said that these new rules will create chaos on campuses. At the same time, there were protests in different districts of Uttar Pradesh. In Aligarh, student groups blocked the cavalcade of BJP MP Anup Pradhan. They burnt effigies of the UGC. In Sambal, members of the Brahman Shakti Sangh have protested, calling the regulations a black law. In Kushinagar, hundreds of members of the Brahmin community, led by the International Brahmin Organization, protested and said that these rules will undermine merit and equality. Although I must point out here, authorities have said that all of these protests were completely peaceful. Now, a quick recap on what these rules are. On the 13th of January this year, not long ago, the government notified, it's a mouthful, I will say it, the Promotion of Equity in Higher Education Institutions Regulations 2026. These rules were made with the purpose of preventing caste-based discrimination on campus, replacing the previous weaker guidelines that were in place in 2012, and making compliance mandatory in universities. They have asked, what the rules mandated were mandatory equity committees, so basically set up a committee on every campus, equity opportunity centers, helplines, complaint portals, and institutional accountability on complaints that are registered. Now, they triggered widespread protests, particularly from general category students. Now, before we go further, we have to first understand why these rules were brought in. And the reason why I want to get into this is because a lot of the criticism has said that the UGC suddenly decided to do this, or the government has overnight decided to do this. That is not the case. So we have to clear that up first. These regulations were actually framed because the Supreme Court asked for these rules to be framed, because it was examining the failure of universities to effectively implement the 2012 UGC anti-discrimination rules. So basically, these rules are they're not new. In 2012, the UGC had introduced an entire set of guidelines, but they were very weak and they were not implemented. This was a case filed by the mother of Rohit Vemula, the PhD student in the University of Hyderabad who died by suicide in 2016 after caste-based harassment, after the system repeatedly failed him. And also the mother of Payal Tadvi, the resident doctor who died by suicide in 2019, Also, due to caste-based harassment by seniors at Mumbai's Nair hospitals, the very doctors who were meant to actually teach her were discriminating against her. Again, the system failed the young Payal Tadvi, who had become a doctor but was still facing discrimination. Now, what had happened was both of these women, the mothers of these two young people, went to Supreme Court and appealed to the Supreme Court in a PIL, saying that the University Grants Commission has anti-discrimination rules, but they are simply not being implemented. So please look into the matter. Now, these rules, I must point out to you, the ones that were already in place were not mandatory. So it was sort of like a guideline or a suggestion. Many institutions didn't implement them at all. They were complaints that were ignored, mostly delayed, not resolved, and so the system was failing the students who needed the help. Now, after this case went to Supreme Court, and Supreme Court heard the entire case and asked for justification from UGC and the Government of India, it then reached a conclusion that the 2012 rules as they stood were toothless, and they held no accountability, and as a result nobody was implementing them, and that is why the Supreme Court instructed the UGC to frame tighter guidelines that are mandatory, that they will have to be followed, they'll have to be implemented with accountability on how it is being implemented. So that is where these rules came from. They didn't get up one morning and decide to do it. The Supreme Court instructed them to do it, and the Supreme Court pointed out what flaws in the existing system needed to be fixed. So the idea that this happened all of a sudden is not true. Now, the second thing we have to look at is the UGC's own data. Now, UGC released data saying that complaints on caste-based discrimination in the last 5 years have gone up 118%. What was the data that it had? That in 2019, they had 173 complaints, and in 2024, that went up to 378 complaints. Now, this is central government's, this is the basis of the central government's argument that stronger enforcement was necessary. But a lot of the counter arguments for this is that what is 378 cases when there are crores of students studying across campuses in the country? It's a drop in the ocean. There's another argument that says cases are going up because now people are able to file cases. So it actually doesn't show, an increase in discrimination. It shows an increase in the ability to file cases. Now, these are two different sides of that argument. But it is widely accepted that discrimination in India against caste is institutionalized in the structure, in the society. And it finds its roots all the way down to the canteens, to the hostels, to the classrooms, to the administrative officers, to the assignment of projects, to entry in the library, to entry in sort of computer rooms. There are many incidences, and it's recorded and widely accepted. Now let's take a look at what these UGC rules are and how they were different from the previous rules. And then we'll find out what the issue was, right? So the rules came out, and as soon as they came out, they replaced the previous set that was out in 2012. Now, one of the features, like I said, was mandatory equity structures, an equity committee that would basically, like it happens with sexual harassment in workplaces, you have a committee, and every time there is a complaint, the committee meets and examines that complaint. An equal opportunity center, a helpline, and online complaint portal. Now, earlier these were optional. Now they're not optional, they're mandatory. Then, for the first time, there was an expanded definition of discrimination. OBCs were explicitly included along with SC/STs. Women and people with disabilities were to be represented in those committees. Then there was institutional responsibility. The head of the institution, whether the dean or the principal, would be held directly responsible for preventing discrimination, ensuring that complaints are addressed, and ensuring compliance with the regulation. They also had to file a report once a year about every complaint that is received and also how they have dealt with those complaints. Now, if a complaint is received, what happens? That's also clearly written out. That people can complain via online portal, email, or helpline. And if the person wants their identity to be protected, then the committee should protect the identity of the person who has filed the complaint. Once the complaint is received, the committee will meet within 24 hours. They submit a report within 15 working days. The institution must act within 7 working days. Criminal cases must be referred to the police immediately, and appeals can be made to the ombudsperson. Now, here's a crucial change. the provision for punishing fake complaints was removed. Now, earlier in the previous 2012 guidelines, there was a provision that if there was a fake complaint that was filed, that the university could take action, including a warning or suspension, or censure, and this could happen either to a teacher or a student. Now, in this particular case, that clause has been removed, and the UGC argues that complaints discourage victims from reporting discrimination, because when you penalize someone for a false complaint, now how do you establish that the complaint is false? In a lot of cases, if there isn't enough evidence, and the committee has said that, we don't believe you, you could say this is a false complaint. So at times, discriminated or oppressed caste students will feel that even if they file a complaint and they are dismissed, the complaint could be called false and they will be penalized against, and that is why having having penalties for false or fake claims actually discourages reporting. This is the UGC's argument. Also, strong penalties for the institution. If the institution violates the rules, UGC said that it could be barred, unrecognized, or will no longer be allowed to offer degrees. So these are quite strict in terms of penalties for institutions that don't follow the rules. Now, let's talk about why the students are protesting these rules. One, they're talking about the exclusion of the general category in discrimination. Why does discrimination, they say, apply only to SC, ST and OBC groups? They also want mandatory representation of general category students in the committee. They've said that there's no safeguard or penalty against false complaints, and there will be harassment and false accusations against them that will ruin their lives. And the short timelines will force institutions to make rushed decisions without proper investigation. So the protesters are actually describing this as reverse discrimination. What do the supporters of these rules say? So this is the counter argument. Caste discrimination in India is structural and historical. So basically, like I said, in an educational institution, this is widely documented. When Dalit students make it, or SC/ST students make it into education institutions, there have been cases when professors discriminate against them. They're called quota students in front of everybody. They're told that they cannot keep up, that they are wasting space, that they shouldn't be allowed here at all, that they shouldn't be allowed to touch the equipment, they shouldn't be allowed to touch the patients, they shouldn't be allowed to touch the plates, they shouldn't be allowed inside the computer lab or inside the library, or they are actually polluting the spaces that they enter, the studios in which they learn how to use cameras. There are many cases where this sort of thing happens, and it's structural. So they face discrimination not just from their professors, but from the people in the canteen, from the people in the hostel who run their hostels. It is widespread. And so the rules that need to protect these students also need to be very strong. Neutral laws, which just say discrimination is anybody against anybody is against anybody, fail to protect marginalized groups, because you're assuming in a neutral law that everybody is equal, and that is not the truth. I mean, as an example, consider what would happen if a upper caste male student files a complaint. If a female student files a complaint, and then at an intersection, if a Dalit student files a complaint, worse still, if a Dalit female student files a complaint. Will these, in all honesty, do you believe that these 4 different complaints will be treated the same way? I'm just giving you a minute to think about it. Do you believe, honestly, that these complaints will be treated the same way? The representation inside the committee that hears the complaints is there to build trust. It's not to exclude, but to build trust, because when an individual feels that someone who understands my position is in the committee, then I will not be completely isolated. I am not having to explain to someone from the, from the higher or the upper castes that this is what I'm going through, because that person cannot identify. They have never lived that life. They have never seen that discrimination. They couldn't possibly imagine what that is like. So it's really important to have representation inside the committee. I know as a woman, when the Vishaka guidelines came out and the ICCs were being set up in our offices, it was really important to have women in the room when a woman comes in to actually file a complaint and say, this is what happens to me. The more women you have in the room, more comfortable you become. Penalties for false complaints deter genuine victims, which we have already gone over. And targeted protection is necessary because of the sheer importance of the problem and what it costs a young person when they face this sort of discrimination. It's sort of like, and the argument that laws will be misused happens rampantly, right? Divorce, in divorce courts, there are arguments that the dowry laws are being misused. There are arguments that the rape laws are being misused. There are arguments that the POCSO laws, which is the law to prevent crime of a sexual nature against children, are being misused. And the SAST Act is being misused. But if you consider the social evil that these laws are actually fighting against, the fact that 7,000 women in our country are burnt every year because of dowry. That's the social evil we're fighting against. The number of children who are raped, number of women who are raped, murdered, slaughtered. When you fight a really serious social evil, you need to have a law with teeth in order to be able to do that. So these are the arguments that people who are for these rules have been making. What has the government said in response to the protest? Education Minister Dharmendra Pradhan has said, no one will face harassment, rules will not be misused, everything will remain within the ambit of the Constitution. That is what has happened so far. Come to today. The Supreme Court heard the case today. It was given priority, it was heard immediately, it was resolved immediately, which is great because that is how important cases need to be tackled. But I must point out the Supreme Court has not had that kind of time for all important cases. It has had this kind of time for some important cases. Now, the bench of the Chief Justice of India, Justice Surya Kant and Justice Joy Malai Bagchi, heard the case, and there were 3 petitions challenging these rules. What the Supreme Court decided is to basically stay the laws, stay the rules, and go back to the previous set. So basically, as of now, it is a victory for those who have protested. The rules have been pulled away, and we've gone back to the old setup. So what did the Supreme Court say? This court has stayed the UGC regulations, put them on hold, saying, and I'm quoting here, if we do not intervene, it will have a dangerous impact. It will divide society. It will have sweeping consequences. The court said the language of the regulations is prima facie vague and capable of misuse. Second point, the court has basically, in order to avoid a vacuum, revived the 2012 guidelines. It's basically said that the 2012 guidelines will come into force, so that old framework is back in operation. Now, I want to point out here, this is the same framework that the same Supreme Court had said is falling short, it's toothless, and it's not being implemented at all. So now the same Supreme Court, after this entire exercise has happened, has decided to basically roll it back. And it's interesting that we've seen this happen a couple of times. Also with the case of the stray dogs and, the rules, the Supreme Court pass a judgment and then the Supreme Court itself will put the same judgment on hold. The matter will now be heard on the 9th of March. The court has issued notice to the Centre and the UGC for responses to what it has asked for. But what has it also said? It has also basically said that the rules need to be re-examined by a fresh committee of eminent jurists, experts familiar with social realities, who can think about how society must behave outside campus if we create such a framework right now. So what has happened is, and the court has not given a timeline for this committee and what they have to do. So the rules, as we know, have been put on hold. They've been shelved. The old rules have come back. Remember, the old rules have no teeth. They were accepted by the Supreme Court themselves. And now they have asked for a committee to come in and look at these new rules and decide what needs to be done without a clear framework or a timeline for this committee. So the rules as we know it right now are gone. Even though the court has decided, we'll continue hearing the matter in March. But what did the court say was troubling about these rules? Now, let me go over it one by one. The court, number one, was particularly concerned with the definition of discrimination being caste-based, saying only the basis of caste and tribe against SC, ST, OBC is not okay. Why caste-based discrimination has been separately defined when regulation says that religion, race, caste, gender, region, disability, all of these things are taken into consideration. Why is there a separate discrimination, a separate section only on caste-based discrimination? Secondly, it has said the exclusion of general category students presumes only certain communities face caste discrimination. It leaves general category students without institutional remedy. And then came the question of ragging. The bench said ragging is one of the most common forms of harassment on campus and it has not been addressed at all. And when harassment happens, it's mostly junior versus senior and caste does not exist. It also said, hypothetically, what if there was a South Indian student who's being harassed by a Northeastern student who was facing harassment? It has nothing to do with caste. Although these rules have been written about place of birth, region, gender, all of these things, but the court has also said, what if there is a junior general category student who is being ragged by a senior SC student? Then they get no protection at all under these rules. The bench made unusually strong observations in terms of social coercion. It said, whatever we have gained towards becoming a casteless society, we are now becoming regressive. And Justice Bagchi said unity in India must be reflected in our institutions as well. Now, Senior Advocate Indira Jaisingh, who appeared for the PIL in 2019 and is now arguing for the rules, she actually said that please hear our side of the story as well, because she wasn't, the court said we will hear it, but for now we're first putting this on hold and then we will hear your side. She argued that the regulations were born out of real failure, that caste discrimination continues even after 75 years of independence, and the court must examine why only means definition of caste-based discrimination. Justice Bagchi acknowledged that this is a question of discrimination within discrimination. This has troubled the Supreme Court from the very beginning. So where does this leave us now? Basically, the UGC 2026 guidelines are on hold. They're not going to be enforced. So everybody who has been protesting, this is a victory for you. The 2012 guidelines have come back into force. The Supreme Court is hearing the matter on the 19th of March. And there may be a possible redrafting, but we don't know how long that is going to take. So, like I said, I'm interested to know what you think of this entire issue. Please let me know in the comments. I promise I read every single comment that you write in these videos. Thank you so much for your support and thank you for your comment in advance.